This video is for anyone considering objecting to a federal COVID-19 vaccine mandate on grounds that it violates a sincerely held religious belief, practice, or observance. While I do get into the weeds quite a bit in this video, having consulted and advised many people on this issue, I found that getting into the weeds is unavoidable. This is Christian attorney R.L. Johnson, lawforlife.us. If this is your first time to the channel, this channel is all about addressing legal issues from a Christian perspective. If this is something in which you have an interest, be sure to subscribe to my channel. In today's video, I will be covering the 5 federal COVID-19 mandates. Particularly, I will be looking at how the federal mandates affect individuals who do not want to take the vaccine due to a sincerely held religious belief, practice, or observance. So let's start by clarifying, how does the law define a sincerely held religious belief, practice, or observance? In most cases, whether or not a religious practice is sincere or not is not at issue. However, in those cases in which the issue does exist, the government defines religious practices to include moral or ethical beliefs as to what is right and wrong, provided these moral or ethical beliefs are sincerely held with the same strength of traditional religious views. With this definition in hand, the first thing that I want you to take away from this video is that all of the federal mandates discussed in this video are subject to certain federal laws protecting a sincerely held religious belief, practice, or observance. For example, Title VII of the Civil Rights Act of 1964. Because Congress has not yet enacted a law mandating vaccinations, the mandates that have come out of the federal government have come from the executive branch. Primary among them are, first, the President's federal employee mandate, which the courts have enjoined in part. Second is the President's federal contractor mandate, which the courts have enjoined nationwide. Third is the Occupational Safety and Health Administration, or OSHA's, large employer vaccination and testing mandate, which was enjoined by the Supreme Court of the United States and later withdrawn by OSHA itself. Fourth is the Office of Head Start's Head Start mandate, which several federal courts have enjoined pending ongoing litigation. And finally, there is the Center for Medicaid and Medicaid Services, or CMS's, Medicare/Medicaid provider mandate, which remains in full effect. Even though most of the federal mandates have been temporarily disabled, the court's reasoning in enjoining or limiting the powers of the federal government is instructive, as further attempted government overreach is inevitable. Now let's look at these one at a time as they stand on the date this video is posted. Before getting into the federal mandate, it's important to note that nothing that the federal courts have done regarding federal mandates, pro or con, in any way prevents a private employer from implementing its own private mandate regarding employee vaccinations or use of protective gear, and that none of this legislation touches or concerns a private employer's ability to regulate what happens in its workplace. In another video, I will address how the following federal mandates are limited by the Federal Civil Rights Act of 1964. Now first, we have the Federal Employee Mandate. This was enacted on September 9th, 2021 by President Biden under Executive Order 14043. This order instructed each agency under the President to implement a program to require COVID-19 vaccinations for all federal employees, subject only to the exceptions required by law, namely those having to do with a person having a disability, a medical condition, or a sincerely held religious belief. All federal employees were to receive under this executive order a 2-dose vaccination by November 8th, 2021, and all federal employees had to be fully vaccinated by November 22nd, 2021. Of course, several federal employees and at least one employee union sued the federal government, asking the courts to enjoin the implementation of the mandate. These suits raised an assortment of claims, including some of the common challenges to state vaccination requirements that I raised or discussed in my video about state police powers. But I think the important thing to note is that both state and federal courts have generally rejected most of the claims that were at that point litigated in the courts. Well, the bottom line is, after much wailing and gnashing of teeth and litigation, the federal court for the Southern District of Texas on January 21st of this year, 2022, granted a preliminary injunction and suspended the enforcement of the federal employee vaccination mandate nationwide. One of the key takeaways from that case, or that series of cases that led up to that decision, was the court's conclusion that the mandate likely exceeded President Biden's statutory authority, as well as his constitutional authority over the executive branches under Article 2 of the Constitution. The other key takeaway is that because the federal employee mandate was enjoined by the federal court in Texas on January 21st of 2022, which was after the compliance deadline that the Biden administration had set, the federal court's injunction only suspends enforcement of the mandate against employees who had not yet complied as of the January 21st deadline. Next, we have the federal contractors mandate. Now, this executive order by President Biden was issued the same day as the federal employees mandate, September 9, 2021. This was done under Executive Order 14042. 14042 required all federal contractors and subcontractors with a covered contract with an executive department or agency of the federal government, including those working remotely from home, to be fully vaccinated by January 18, 2022. Now, over 20 states filed at least 4 separate suits in different district courts to challenge the mandate on behalf of their state agencies and political subdivisions who potentially had a contract that was subject to the federal contractor mandate. Now, in terms of outcomes, as of the date of this video, there's been a lot of litigation. For example, the state of Kentucky sued the Biden administration in an attempt to enjoin enforcement of the federal contractor mandate. Of course, that case was not successful in that court declined to stay enforcement of the mandate. However, in Georgia v. Biden, which was decided on December 7th of 2021, that federal court of the Southern District of Georgia did in fact enjoin a vaccination requirement nationwide. And the important takeaway here is that this case, as well as a series of other cases to follow, as well as some of the more recent decisions out of the U.S. Supreme Court, tend to signal a more limited construction of presidential authority to mandate vaccinations for federal contractors in the absence of a clear statutory authorization. Next, we have OSHA, that is the Occupational Safety and Health Administration's large employer vaccination and testing mandate. Now, OSHA issued this mandate on November 4th of 2021. And what it did was it enacted an emergency temporary standard, or EST. This EST required private employers in every state in the Republic, as well as Puerto Rico and the U.S. Virgin Islands, who had 100 or more employees, to establish and enforce a policy that either ensured that all non-remote working employees were fully vaccinated, with the following exceptions: where a vaccine was medically contraindicated, where medical necessity required a delay in vaccination, and where an employee was legally entitled to a reasonable accommodation pursuant to federal civil rights laws due to a disability or a sincerely held religious belief, practice, or observance that conflicted with the vaccination requirement. And if an employee did not fall under one of those exceptions, the employee was required to be vaccinated fully or to provide proof of regular COVID-19 testing and to wear a face covering when indoors. Now, OSHA set the compliance deadline for January 10th, 2022 to begin the implementation of all vaccination policies, and OSHA set February 9th of 2022 to either receive a 1 or 2 dose vaccination series or to begin regular testing. Now, of course, OSHA's EST was challenged by several petitioners, and those petitioners included covered employees, covered employers, states, and religious groups. And these petitioners sued in several federal courts of appeals, asking the courts to either stay the enforcement of the EST or to permanently enjoin the mandate. Now, the good news for private employers, which is known to most by now, is that the federal employee mandate that OSHA issued was stayed by the U.S. Supreme Court on January 13, 2022, in the case of National Federation of Independent Businesses versus the Department of Labor. The important takeaway from that case is that the Supreme Court concluded that a stay was warranted because the applicants, that is the states and the religious groups, and in private employers, were likely to succeed on the merits of their claims that the EST exceeded OSHA's statutory authority. According to the court, because the EST applied to roughly 84 million workers across industries, it undoubtedly qualifies as an exercise of authority of vast economic and political significance, which the court found would only be permissible if it was plainly authorized by OSHA's enabling legislation. Now, the court only enjoined the enforcement of the act pending other litigation and pending appeals in the federal circuits. However, on January 25th of this year, 2022, OSHA announced that the agency was withdrawing the EST as an enforceable emergency temporary standard. Consequently, the large employer vaccination mandate is presently off the table. Next, we have the Head Start mandate. The Head Start mandate was issued by the Office of Head Start, which is a unit within the Federal Health and Human Services Administration for Children and Families. The Office of Head Start issued the Head Start mandate on November 30th, 2021. This mandate requires all Head Start staff to be fully vaccinated by January 31st, 2022, unless granted a legally required exception based on disability, medical condition, or a sincerely held religious belief. Now, the Head Start mandate also includes a masking requirement for individuals 2 years of age or older when indoors. Thus far, roughly 26 states and about 3 separate lawsuits sued to challenge the Head Start mandate. In each of these cases, plaintiffs filed motions for preliminary injunctions to block the mandate while litigation is pending. The long and short of it is that the result of this litigation, primarily in the cases of Texas v. Becerra, which is in the Northern District of Texas, and the other big case is Louisiana v. Becerra, which covered 24 states in total, all seeking the enjoining of the mandate. Now, both of these courts concluded that the plaintiff states are likely to succeed on their claims that their mandate exceeds the Secretary of Health and Human Services statutory authority. There's also another case which is more recent, Livingston Educational Services Agency versus the Secretary of Health and Human Services. This was filed in the Eastern District of Michigan. In that case, the federal court also granted a stay, temporarily enjoining the defendants, the Department of Health and Human Services, from implementing and enforcing the vaccination provision. This particular lawsuit affects up to 56 unvaccinated individuals, along with a number of unvaccinated individuals that are currently employed in the Head Start program in the Walled Lake Consolidated School District in Michigan. Last but not least, we have the Centers for Medicaid and Medicaid Services, CMS's, interim final rule, which was issued on November 4th, 2021. Now, this particular rule required specified providers and suppliers that participate in Medicare and Medicaid to ensure that their covered staff who directly provide facility and patient care or other services to be fully vaccinated by March 21st of 2022. Now, the good news of the Medicare and Medicaid mandate is that it exempted 100% of all remote workers. Interestingly, the CMS mandate is silent on vaccine exemptions due to disability or sincerely held religious beliefs, practices, or observances that conflict with the vaccination requirement. However, the federal protections found in, for example, the Americans with Disabilities Act and in civil rights legislation would have to be applied equally to the CMS mandate as they are to the other mandates mentioned earlier. Now, the CMS mandate is distinguishable from all of the other mandates discussed in that this mandate was the only one thus far that the U.S. Supreme Court found in Biden v. Missouri and Becerra v. Louisiana that the rulemaking mandate requiring certain providers be fully vaccinated by March 21st of 2022 to fit neatly within the statutory authority granted the Secretary of Health and Human Services by Congress. The Supreme Court said that the Secretary's authority to impose necessary conditions to protect the health and safety of patients served by the relevant providers and suppliers, as well as the Secretary's general authority to issue necessary regulations to support the efficient administration of Medicare and Medicaid, fits neatly within the Secretary's authority. However, the court did acknowledge that not all of the statutory provisions invoked by the CMS mandate contain the health and safety statutory language. The court explained that facilities not subject to the statutory language represent less than 3% of the workers covered by the rule, and that the pertinent statutory language may be read as incorporating the health and safety authorities applicable to the other 97%. The court thus saw no reason to let the 3%, quote, wag the dog. Now, with all of this being said and for the most part done, there is little or nothing outside of existing federal law, that is, the Americans with Disabilities Act, or existing civil rights legislation, preventing a private employer from imposing a vaccine mandate on its employees, which is a matter that I discuss in my state police power video, a link to which I placed in the description box. With all of this said, Christians would do well to remember that the Lord has established His throne in heaven and His kingdom rules over all. Nonetheless, we should continue to pray for our judges because, as it is written in John 19:10, they have no power if it were not given from above. Also, if you're looking for more information or resources on this subject, I periodically post new content and resources on my blog, lawforlife.us. Thank you for watching. God bless.